Gentlemen, let's go straight to today's business. Let's quickly look at the first issue today. Just on Wednesday last week, the president of the Federal High Court set up a task force of judges to look into matters, to quickly dispose of all the pre-election matters. And I think it's the right step in the right direction if you look at that. But I leave you with that to look at what those issues are. Like you people say, the election matters are sui generis, they are unique. Is it because, let me start with Barrister Ophili. How would you actually look at this task force put in place by the president of the Federal High Court?
Well, I think it's an attempt to speed up the process. Okay. Pre-election matters are not necessarily sui generis because it's still a normal process. See that all pre-election matters you come by originating summons, okay. And the only part I will call it, we say perhaps is sui generis is because it's also time bound. It's time bound because you are supposed to comply by we now have practice direction, a new practice direction, okay. 2022 practice direction, okay. Which talks about how adjournments should be, how parties should file processes, and everything you have there is to speed up the process so that there will be proper dispensation and a quick resolution of these issues. Because you know that pre-election matters will move from the Federal High Court, that's the Court of First Instance. And then from there to go to the Court of Appeal, from Court of Appeal to the Supreme Court. Except for some cases where the parties are not contesting beyond the Court of First Instance. Okay. But in most cases, especially when it is very high profile, people are always, taking it to the top direction. I have a case that was filed in May after the primaries in Delta State. Judgment has not been given yet. Judgment has not been delivered yet. We were told at the last sitting when all processes were moved and ordered that in 24 hours they will inform us when judgment will take place. But if you look at May to now, you have the 180 days already far spent, okay, within the
about 6 months.
Yes, so and you still have options of appeal. Okay, at the Court of Appeal, you have 60 days to resolve. Wow. And then you still have, if you are going to the Supreme Court. So the process, the task force being set up now is to ensure that all these pre-election matters are extinguished before the election. Okay, so that you don't have supposed parties who ought not to have gone for the general elections, okay. And then they make it to the general elections while the pre-election matters are still pending. You understand? Because you're going to have issues. By the time the case at the pre-election angle is terminating, not at the favor of the party that has gone for the general election, you are going to have problems. So it's a good time to. I think they should have even constituted this task force before now to ensure that. But it's a good thing. It's better late than never. Let's have these matters dispensed.
Let's hang it there. It's better late than never. Barrister Chime,
yes.
Actually, if you look at what the president of the Federal High Court was saying, he said that the court is flooded with this pre-election matter because they have a very large chunk of them. Yes. And if you remember vividly the case of Amechi, how Amechi became governor. He was, so I guess this is, but if you look at that, how would you view this from what Barrister Ophili said? He said that in May, they are still expecting judgment, and this is November.
Yes.
The 4 weeks given to these judges, these task force judges, do you think that is visible?
Well, let me first and foremost begin by saying that every election cycle in Nigeria is always characterized by disputations arising from primary elections. So it is not uncommon to see, volume of pre-election matters flooding Nigerian courts across Nigeria. So what the Chief Judge of the Federal High Court has done in essence is to empanel some judges who will sit over these pre-election matters and be able to dispose them before the 2023 election, because we are also going to have post-election disputations, like what we call election petition matters, which is also a sui generis, which will also empanel tribunals to try to try those matters. But because of the nature of our election system or electioneering system, there is almost always disputes that rise after every primary election. Now, the Nigerian courts, particularly the Federal High Court, has the jurisdiction to hear these pre-election matters. And they are hearing these pre-election matters together with their regular civil and criminal jurisdictions, which they already have. So this will also hamper on the effectiveness and the speed with which matters are being tried and concluded in our courts. So what the CJ has done, in essence, is to have a clear docket where these pre-election matters will be dispensed with. And we also are aware that pre-election matters also time-bound. You have a limited time within which to institute and conclude. So most often than not, you see that these pre-election matters have been instituted, but because of the limitation of time, the court may not be able to give a definite position in terms of judgment or decision in that matter. So in order to avert these challenges, and also couple with other post-election petitions or matters that will come up, the CJN, in his wisdom, which I believe is proper, and which he has the power to do, has empaneled this set of brilliant judges to sit and quickly dispense with these pre-election matters. And this points out to one thing, it seems politicians, even our courts, there are decisions of the Supreme Court, the Nigerian courts should not be interested in the internal affairs of political parties, except when those political parties have contravened their own constitution or electoral laws or guidelines. So you see, many a time, the politicians or the what do you call it? The political parties do not play by the rules. They have their own constitution. They have rules guiding their primary elections. But you see, along the line, they shift the goalposts in the middle of the match. So which gives rise to these disputations, which also the Federal High Court had jurisdiction to entertain.
Okay, Barrister Ofili.
Yes.
One thing is mind-boggling about this whole tax force setup. The president, that's Justice John, was saying that the judges that will make up this tax force, that they are going to suspend their regular cases. What happens to criminal cases or cases where some people are already in cell and they need to dispense of this matter? If, for example, there's a case, probably they've arraigned somebody and the person is supposed to appear maybe this week and the person is innocent. Now, because the judge will no longer be available to hear the bail matter and everything, what happens if he's remanded in prison? Who pays at the end? I hope you understand what I'm saying. Yeah, because if you say they should suspend their regular cases, what's your take on that?
Yeah, no, I laugh because you said the person is innocent. Nobody can say who is innocent or not.
No, at the end of the case. At the end of the case.
Okay, As you know, the issue is that there is an expediency here. We are going to run into constitutional crisis if this
matters are not
if this task force is not set up to resolve this issue. We'll run into crisis. Okay. What I think should be done is that people who are standing trial for cases, or of course, almost all offenses apart from murder, maybe, which is also available. Okay. So, if the counsel to the case you just referred to had brought a motion for bail and all that, and possibly bail has been granted in most cases, but The defendant, yes, defendant who is in, and then to perfect bail, you don't need the judge, the same judge that you can always, the court have a way of
assigning.
Any judge can look at it.
Okay.
Any judge can look at it. There are cases where the particular judge is not on seat, that is meant to determine a case, a criminal case. The court have a way of moving to any available judge to look at it. Okay, so there's always going to be a remedy. But as for this issue, we must dispense with it, because if you look at the way this election, I mean, this year we have more pre-election matters for one reason. It's the year that we changed the Electoral Act. And then many of the political parties didn't understand the import. Like the case I'm doing, you see, the Electoral Act gave 3 options as to primaries. Direct, indirect, consensus candidate, indirect. Do you understand? If you choose any of the options, there are further procedures you should adopt. Like the court says, if you choose indirect now, the primary should be determined by the party constitution. Do you understand? But in this case, instead of the party to determine the primary by the party constitution, the party just went to the Electoral Act, came out and said the Electoral Act says that adult candidates should be the ones that should vote. And all statutory candidates were asked not to vote, were disenfranchised. That's what the 7th respondent, the PDP, did. And parties who were disenfranchised went to court. You understand? So it happened all over the country. And then if you look at the Electoral Act, you see, that's why you have more. Sometimes not even from aspirants, even though the electoral as aspirants should be the ones who should go to court. But if you have people whose rights have been infringed upon in the process of, don't they have, by fundamental right enforcement, can they come and then bring an action before the court? So you have a lot of disputes in electoral matters like this.
Barrister Chime, no doubt, we know that we have a large volume of these cases in court. But if you look at what happens, INEC is also working with the Electoral Act. And I know that they are following their timetable. They are following it. If no candidate is presented, probably a month before the election, and the courts, you know, the way we do our court processes, that was what I was asking you, that the 4 weeks that was given to this panel, is it feasible? Looking at that setup, INEC too is working with time. Would they be able to substitute candidates if they are not able to meet those 4 weeks?
Well, there are electoral guidelines. As far as the court or judiciary is concerned, they don't have business with who emerges a candidate for a political party. They are interested in ensuring that the process of emergence is in accordance with the constitution of the party or the electoral guidelines. So once the political party did not meet up with that guidelines or did not follow their rules, they will be disqualified. Of course, the implication is that they will not have a candidate. It is not the first time it's happening in the history of this country. As far as I'm concerned, this year we had like 2 or 3 states where a certain political party have been disqualified from contesting this election. So the courts are only interested in fairness and to ensure that the proper things are done. As for the time within which to dispense with these matters, of course, there's what psychologists call avoidance conflict, where you have 2 negative outcomes should you choose one. Even if the courts are allowed to be entertaining these pre-election matters, together with their regular matters, the matters will still suffer. If the electoral matters do not suffer, other regular matters will suffer. So whichever way anyone looks at it. In fact, as far as we speak, I have a matter that's supposed to come up tomorrow. I got a message that particular judge, I wouldn't want to mention them, will no longer be sitting from tomorrow being 7th to 7th of December because it's part of the panel. Yes, that have been constituted. So, but by and large, the essence or intention of the judiciary, and in particular the Chief Judge of Federal High Court, is to ensure that these things are speedily dealt with so that political parties will know their stand. Those who have, so they don't have to waste your resources. The INEC don't have to waste their resources, in fielding a candidate who will be removed at the end of the day. And also to strengthen our own democratic institution. Because we saw, as an African country, I can't recall, that just concluded the election a few weeks or months ago, Kenya. And within 14 to 21 days, the Supreme Court had a definite decision on the matter. Yes. So we are looking forward to that time where the judiciary will have to dispense with both pre-election and post-election matters before a candidate is declared or sworn in, so that we will have to, remove this issue of having to go back to square one, spending money, having another election, or put someone who ordinarily ought not to be there. Because we still have a case of in Imo State, governor of Imo State is still continue to be a thorn in the flesh of the judiciary. So we have to avoid such similar situation in the future and ensure that property is done. Okay,
maybe one final one about the Electoral Act. Of course, the amendment. I get the political parties. They have lawyers. They have legal advisors.
Yes.
Why is it difficult for them to interpret those laws? Or do they want the judges, our constitution, or the law to do it for them? Because you just said something that the case you are handling, the reason why some people went to court was because they have seen some, of course, we always look for those lacunas, those void areas to, does it mean that they cannot interpret to their parties so that to limit this?
This is one of the
before the elections.
One of the questions I raised too in this case when I looked at how the PDP went about the primaries in the states. So I asked myself, I mean, I looked at the ESCO, the party ESCO, and then the legal team of the party in the state. Okay. You understand? And the first question I raised is, how come these people went this way? And I was reliably informed that that office is vacant, that there were no lawyers there who would have guided through the process. So, you see, our political parties have a way of creating problems for themselves. You remember in Rivers State, when the Electoral Act have said, okay, you need to do what? Contest primaries.
Yes, to conduct it.
Conduct primaries. Now, instead of the APC to conduct a proper primary, they broke into factions, 3 factions, and conducted 3 different primaries. And then send the names, 3 different factions to send the names of 3 different persons to INEC.
Office.
Then INEC actually, INEC were present in one of the
3.
Those ones that say they are the superior ones. Now, when it got to Supreme Court, because the matter had to go to court, when it got to Supreme Court said, you know what, APC will have no candidate in this election. Yeah, because if not for the courts, politicians would have long destroyed this country.
I think it happened in Zamfara too.
In Zamfara too. Yes. And recently too, there is
states.
You see, because the Electoral Act is clear. You ask yourself, don't this party, don't they have, or these factions, don't they have lawyers within? Okay. And so when we break into factions, at the end of the day, the best way to address is the way the Supreme Court addresses it. Don't contest in this election, because you have turned the system to a prodigal empire. You cannot sustain this anywhere. It's crisis. So the best thing is to shut them down. Imagine if there were no Supreme Court or no court in the land. The society will be in chaos.
Barrister Chime,
yeah.
So what's your take on it?
Well, like I've said it earlier, that the judiciary, their own stake is to strengthen the institution and strengthen our democratic ethos, ensure that the proper thing is done. So it's not left for the key players, which is the political parties and the politicians, to play by the rules. The irony is that when the politicians, did not get it through their own means, they now decide to frustrate the entire process, which leads to litigation in court. And at the end of the day, it will begin to look as if it is the judiciary that now determines who rules or who wins an election. So there must be an end to that. Election must be won and lost at the ballot and not in the courts.
I love that. Election must be won and lost
at the ballot,
not at the courts.
Yes.
So we will leave that for the authority to take that decision.